Welcome, everyone, and thank you for joining us today. My name is Andy Bloom. I'm the Chief Privacy Officer at McGraw-Hill Education, and we're very happy to speak with you today about student data privacy for U.S. K-12 institutions. I'm joined by Lynette Attai. Lynette, would you like to introduce yourself?
Sure. Thank you, Andy. I am the president of Playwell, which is a compliance consulting firm. I work with companies and organizations of all shapes and sizes, helping them to navigate their regulatory and self-regulatory obligations around issues related to data privacy, user safety, advertising, marketing, and content. I also work with schools and districts to help them build their infrastructures of compliance. And I currently serve as the project director for COSIN's Privacy Initiative and their Trusted Learning Environment program. I'm very happy to be here. Thank you for having me.
Well, thank you, Lynette. So we want to talk about privacy today, obviously, in U.S. K-12 institutions, but we do want this to also be an interactive session. So please don't hesitate if you have any questions to enter them into the Q&A location on your screen, and we will answer them as they come in. First, I wanted to just talk about our agenda a little bit. So we're going to discuss what is privacy, and why is it important. And then Lynette will discuss a little bit of the regulatory landscape, both at the federal level in the U.S. as well as the U.S. states. And then we've got some great privacy resources that we'd like to share with you as well. And then leave a little bit of time for some Q&A at the end. So the big question is, what is privacy? I've been working in privacy for a long time now, and it's a question that changes a lot, but I think the core sort of still remains the same. And privacy is really about making sure that information, personally identifiable information, is appropriately used, collected, handled, and governed. It sort of then begs, what are we talking about when we are talking about personally identifiable information? So it really does vary a lot depending on the field that you're in. But again, sort of the core stuff remains the same, and it's any data that you can use to directly identify an individual, or you can combine with other data to directly identify an individual. So a name, for instance, clearly you can identify someone based on their name, typically off of their address, a student ID, even login information can be used to identify an individual. So those are all PII fields, or personally identifiable information, by themselves. You don't really have to combine anything else with it. Then if you think about some additional information, like you've got academic, health, and disciplinary records, when you tie those to student information, obviously they're PII, and there will frequently also be information in those that would make it identifiable by themselves. So that sort of leads to the next one, which is information when combined. So I've got demographics and birth information on the screen, and those are two good examples of if you take a couple of fields, you can combine them and really identify an individual. So if you just say October 6, 1970, might not mean anything to anyone. There's probably, hundreds of millions of people born, well, probably not that many, but millions of people born on that day. And but if you say that and then you say Champaign, Illinois, someone can probably identify Andy Bloom with that. I'm guessing there weren't too many people born in Champaign, Illinois on October 6, 1970, but that should give you a good flavor of what it means when you can kind of take several different fields and put them together to identify someone. It looks like we're having some volume problems, so let me see what we can do to fix that. Hopefully that's a little bit better. We can go from there and see how it goes. The one thing to remember, though, is for student PII especially, it's ultimately defined by the laws in your state. So the login information is a good example of some very specific fields that have come up recently where a new state law has defined that as PII. And there are other examples, but it's important to know what your state law says to understand exactly what is PII, student PII. So the next question is really, why is privacy important? And that might seem like sort of an obvious question, but it isn't always. So first, there are obviously legal and ethical limitations on how personally identifiable information is collected and used. And a lot of those are laid out in federal and state laws. Many institutions have their own policies around that and making sure that data is handled the way that they want to. As an organization, McGraw-Hill Education has contracts that sort of dictate how we control, collect, use, and share student data. So there's various kind of legal issues around how that is done, federal and state laws, obviously. And we're in an interesting time right now, especially because technology is changing very rapidly. There were probably not too many years ago when you might have an online classroom management platform, but it was really, it could take attendance and help you track grades and things like that. But, technology has moved along, and we're now getting into where there's adaptive learning. And, you collect more information the more you're actually doing. So the ever-changing technology landscape has increased that collection and use of student PII. And as third parties like McGraw-Hill Education is there to help business. So you have to additionally deal with the fact that you're creating contracts with third parties to make sure that they're doing the right thing. FERPA sort of, and Lynette's going to talk about this a little bit more as we go along, but one of the key things to remember is that in the educational environment, the school is in control. So how you want the data collected and used is up to you. You just want to lay that out in the contract, but it also means that ultimately the school is responsible. So you want to make sure in contracts that you're also being very clear with people what their responsibility is if there is an issue. So why don't we move along? Lynette, do you want to start talking about the regulatory?
Sure. Absolutely. Thank you. So before we dive into the laws and what they are and what they mean, I always find it helpful to start at the beginning with the concepts behind the legislation. As you know, and if you're new to this space, as you'll see as we go along, there's an incredibly robust and complex matrix of legislation that wraps around student data privacy. And when things get too complicated, or if you're getting a little lost in the weeds, I always find it helpful to go back to the underlying concepts and remember what it's all about. So we start with the Fair Information Practices Principles, and these are the concepts that underlie almost all federal privacy regulation in the U.S., regardless of sector. So this is the foundation upon which we think about how to legislate privacy. And the concepts are really simple. We start with transparency, and that essentially means we need to be clear what data we're collecting, what we're doing with it, how we're handling it, and we do this most often and most obviously through our privacy policies or through other privacy notices that we provide to users. Next concept is about individual participation, which simply means that our users have to have choice about what data we collect. They have to agree to our collection and use of the data. And when we're talking about a school vendor relationship or a district vendor relationship, that's primarily handled through a contract, as Andy suggested. But also the vendor will have privacy policies. And schools and districts will have privacy policies on their website to inform their students and parents and other community stakeholders how they're collecting data. So It's really all about making sure we're transparent and making sure the user has a choice. They're agreeing to come here. We tell them what we're going to do, and then they have a choice to stay or to go. Purpose specification simply means that when we collect data, it needs to be for a specific purpose. Right? So we shouldn't be collecting data that we think we might need at some point down the road, but we collect data for a specific reason, and we define what that reason is. We only collect what we need. We act under the data minimization premise, which says if you don't need it, you don't collect it. Right? And you collect as little as you need in order to provide the features and functionality that you want to offer to your users. When we talk about use limitation, we simply mean that you collect the data for a specific purpose, so you shouldn't use it for anything else unless and until you've given your users notice about what else you want to do with it. You've given them information about what else you might want to do with that data, and you've given them the choice. They consent, they participate, they agree to allow you to use the data for that purpose. We have to maintain the quality and integrity of the data. We maintain the wholeness of the data. Right? We preserve it from corruption and degradation. We have what the regulators will often refer to as reasonable security standards in place. We want to protect the data from unauthorized access or loss. And then we want to have some accountability and auditing around our work. We want to have some governance to make sure we are keeping our practices at the level that's required given the data that we have on hand. So you're monitoring your work, you're monitoring your compliance. And so these concepts, this is, if you sort of understand, if you take away very little from this presentation, this is where I always say to clients, to schools, these are the fundamentals. And this is, if you're starting a privacy program, the best place to start is to start with this and think about how you would apply those concepts to the work that you're doing. But now let's talk about what the federal climate really looks like. And this is a sampling of the key regulations that are at play around K-12 student data today, but not all of them. In the U.S., we protect privacy by sector. We have special protections around financial data, special protections around health data, special protections around children's data, and student data. And this, again, start at the beginning. On top of FIPS, we lay Section 5 of the Federal Trade Commission Act, which prevents us from engaging in what they refer to as unfair or deceptive acts or practices. And what that really means is an act or practice is unfair where it does cause or may cause significant injury, and where the user, in this case, can't reasonably avoid that injury, and there's no counterweight benefit to the user. And then something is deceptive, legally defined as deceptive, when either a practice or an omission misleads the user, or the user is likely to misinterpret what we're saying. So to engage in unfair or deceptive practices is not legal. It's precluded by federal law, like for commercial entities. And the way this comes into play is really simple. What it means is that in execution, the most common place that we see it, or that we would see it in the student data realm, would be with our privacy policy. Our privacy policies are commercial, they're legal documents, and they need to accurately reflect what the vendor or the school, in some cases, is doing with the data. If your privacy policy is not accurate, it can be considered deceptive, and it can be considered an unfair practice to the consumer, a misleading statement. So there is some weight behind the privacy policy and how it needs to be handled. So then, of course, that's not all that we need to work through when we're talking about student data. You have SIPA. So in order to receive discounts offered by the E-rate program, schools and libraries need to certify that they have internet safety policies that address safety and security, unauthorized access, and unauthorized disclosure of personal information, as well as technology protections in place. I sometimes see SIPA referred to as a privacy law, sometimes not, but there are some privacy aspects to it. in preventing unauthorized access and unauthorized disclosure of personal information. And also, in addition to the technology protections to block or filter access to content that's obscene or pornographic or otherwise harmful to minors, schools also have to have internet safety policies in place that include monitoring online activities of minors and providing education for students about what we generally refer to as digital literacy, which is namely appropriate online behavior and online social interactions and cyberbullying awareness and response. Now, I include HIPAA in here. I'm not going to get into too much detail, but we often forget that schools may have a nurse's office or similar medical office on hand, and that data may be HIPAA protected. Now, very important to understand that when we're talking about the K-12 environment, the school is not generally considered to be a covered entity under HIPAA. The data is subject really more to FERPA as part of the education record. Generally, HIPAA is much more applicable in the higher education space. However, there are some K-12 schools that provide medical services and perform transactions, such as sending billing to insurance companies around those services. And so in those cases, if that is reflective of your school or district environment, HIPAA is definitely worth a closer look. Now, of course, the biggest privacy law that we talk about, that we work through, that we comply with when it comes to student data privacy, at least on the federal level, is FERPA, the Family Educational Rights and Privacy Act. And this is the basis for most of the state education privacy laws that we'll talk about. FERPA really identifies rights that parents, guardians, and students over the age of 18 have in regard to the student's education record, and then what FERPA refers to as directory information. And really what FERPA says, FERPA is an access law. It says parents have the right to inspect and review their child's education records. Parents can correct or request that the education records be amended if the records are inaccurate or misleading. And there is, of course, a process that parents need to go through in order to make that happen. They need to send a request to the school. There are some rules around when a school needs to reply. And of course, if a parent wants a record corrected or amended, schools don't automatically have to say yes. If they decide not to amend the records, there are rights built into FERPA for the parent to have a hearing on the matter. The piece, of course, that causes the most discussion when it comes to student data privacy are the rules in FERPA around releasing the information. Now, when we talk about an education record, we're talking about a very broadly defined set of data that includes personal and non-personal information. And FERPA sets out qualifications for when schools may and may not release personal information from education records with and without consent. So schools may release records to certain parties without extra parental consent. For example, they can release education records to school officials with a legitimate educational interest, and we'll talk about that in particular. The data can be released to other schools to which a student is transferring. Then there are specified officials who can have access to the data for audit or evaluation purposes, certain parties in connection with financial aid to a student, certain parties conducting studies that are done for or on behalf of the school, accrediting organizations, and there are some legal exceptions, persons who are authorized parties to a court case, obviously to comply with a judicial order or subpoena. In those cases, it's okay to release the information, and to appropriate officials in the case of health and safety emergencies and state and local authorities within the juvenile justice system. Now, I've got a question. A question was asked, does FERPA cover private schools? So FERPA applies to schools that receive federal funding. Usually we see that most often in two forms. Federal funding tends to come into schools. One is in free and reduced lunch programs, and the other is E-rate funding. So in the absence of receiving federal funding, FERPA actually does not apply to an educational institution. However, it does lay out some really solid principles about data use and sharing. So I hope that answers the question about, does FERPA cover private schools? And the answer is essentially, it depends. If you receive federal funding, it does. Now, FERPA is a really interesting law when we look at it from a privacy perspective because it protects certain information, but at the same time it has a carve-out for information that is referred to as directory information. And when schools want to release directory information, they don't have to get parent consent. However, they do have to offer parents the opportunity to opt out of sharing directory information. So directory information is explained in FERPA as information such as a student's name, maybe their grade, information that would not otherwise be considered harmful if released. And it's an interesting categorization of data because it's unlike any other that we have in the privacy sector. FERPA, of course, was written in 1974, I believe it passed, so really well before we had this climate of privacy and technology around the data. But it allows schools to release certain information about students without parents' prior consent. However, parents do need to be given the opportunity to opt out of that data sharing. And the directory information exception is really designed for situations such as a school wanting to publish a yearbook and wanting to publish names and photos of students in the yearbook and being able to do that without getting parents' advance consent, or being able to publish the roster of who is on the football team or the program for the school play. Each school defines what directory information means for that school or the district, but it is allowed. It is something that schools are allowed to release. So if a school has defined, depending on how schools define directory information, they can release that for a number of purposes. I use the examples of the yearbook and the football team just for illustrative purposes to give you a sense of where this came from. But it is used in sharing data today to vendors. And in 2008 and 2011, FERPA was actually updated to allow third parties, such as ed tech vendors, to whom you may have outsourced institutional services or functions under FERPA. And outsourcing institutional services or functions is a key definition of a school official. And a school official is an individual or an entity to whom you are outsourcing a function or a service that you would otherwise do yourself. However, in order to designate, when you designate an entity as a school official, one of their obligations is to remain under your direct control. Now, when it comes to compliance and enforcement of FERPA, FERPA is what we call a spending clause statute, meaning that schools, districts, educational institutions must follow all of the provisions in order to be eligible to receive federal funding. And then complaints could be addressed by the Family Policy Compliance Office. However, what we see is that only a policy or practice of violating FERPA is going to lead to punishment, not a single violation. And one of the reasons for that really in practicality is that the repercussions for violating FERPA are that the DOE could essentially say to the school or district, you're no longer eligible to receive federal funding. So it's such a stern and very difficult repercussion that it's actually never been triggered, although there have been sort of quiet investigations and letters of review, I should say, from the Department of Education. I have a question that says, what about directory information on the school website? And so I assume what we're talking about is have you published student names and other information that you've designated as directory information on the school website. And that would be fine under FERPA as long as the proper notices had gone out, usually at the beginning of the year, explain to parents what you consider directory information to be and giving them the opportunity to opt out of that sharing. Usually, I would say outside of the law, when working with organizations, I encourage you to think about something else when it comes to sharing student data publicly on, for example, a public school website, as opposed to, say, a private portal that is used only for the students in your school community. And that is to not just consider the privacy implications, but also to consider the safety questions about who's having access, what data are you releasing about the students, and is it information that maybe their parents would be comfortable having out there publicly, Are you telling people where the students will be at particular times of the day? So think through what information you're releasing to make sure, A, it falls under your definition of directory information and that parents have been given the opportunity to opt out of such sharing. And then B, outside of the FERPA requirements, again, outside of the law, think through whether or not there is a potential safety issue with you releasing that information and then make your decision. So, the law only covers us so far, and then we need to consider the other side of the equation. But provided that you have covered your bases, directory information can be released on a school website. There are no particular places where, again, I use yearbook and football team and school play program as illustrative examples. There are no examples in FERPA, so it is at the school's discretion to disclose that information. So then in addition to FERPA, we have the slightly tricky but not often talked about Protection of Pupil Rights Amendment, or PPRA. And what PPRA basically says is that you have to have policies in place and provide direct notice to parents regarding their rights to opt their children out of participating in any activities involving the collection, disclosure, or use of personal information for the purpose of marketing or selling that information, or providing that information to others for that marketing or selling purposes. And how this comes into play is when schools administer surveys and conduct analyses or evaluations funded by the U.S. Department of Education, they have to make that survey or instructional material available for inspection by parents. And schools also need to obtain written consent from parents or legal guardians before minor students would be allowed to participate in surveys that ask questions regarding what we informally refer to as the sex, drugs, and rock and roll criteria, which are things such as mental and psychological problems, political affiliations, sexual behavior and attitudes, illegal, antisocial, self-incriminating and demeaning behavior, criticism of other individuals with whom the student might have a close family relationship, questions about legally recognized privileges or similar relationships, such as with lawyers, physicians, or ministers, asking students questions about their religious practices or those and the beliefs of their parents or legal guardian, and asking questions about income other than those questions required to determine eligibility for financial assistance programs. As with FERPA, PPRA is also enforced by the Family Policy Compliance Office, and parents can file complaints with FCPO, and schools could lose federal funding if they don't comply with PPRA notice procedures. However, as with FERPA, the Compliance Office tends to work with schools to come into compliance. To date, no school has ever lost funding for not complying with PPRA notice provisions. So there's not a punitive approach on the part of regulators around these rules. However, the repercussions for violating can be extreme and severe consequences for schools and districts. So if that weren't enough, we've got one more on the federal side that we're going to talk about, which is COPPA, the Children's Online Privacy Protection Act, which is enforced by the Federal Trade Commission. And unlike what we've talked about previously, COPPA applies to vendors. Schools have certain rights and responsibilities around COPPA, but the liability for COPPA sits primarily with the vendor. And what COPPA does is it regulates collection and use of personal information from children under the age of 13. And the law's primary purpose is to place parents in control of the information collected from their young children online by requiring that the parent consent to the collection and use of that information before the child is asked of it. It requires that vendors collect the minimal amount of data needed to provide a feature to a child. It prohibits behavioral advertising targeting of young children, something that's also been precluded under industry self-regulation guidance for many, many years. And it requires reasonable security standards and similar due diligence around third parties. Now, when I say that COPPA requires that the vendor obtain prior consent from the parent before collecting information from a minor child, when it comes to education technology providers, COPPA does allow schools to provide consent on behalf of parents to information collected by the vendor when the student information is going to be used solely for the benefit of the school and for no other commercial purposes. So in the case where the vendor is not intending to make commercial purposes of the data, they're only collecting data to provide the features and functionality for the schools, which tends to be the case for the most part with ed tech providers. In those cases, the school can provide consent to the vendor on behalf of its parents. However, the vendor should still provide the school with its privacy policies, and the vendor does maintain other obligations around COPPA with respect to protecting the data, providing access to the data, and of course, FERPA still applies. So I often hear from schools, the question from schools about, well, if a student is over 13, or 13 or over, I should be okay, right, because COPPA doesn't apply. And we need to remember that FERPA applies for students of all ages. So we need to make sure that we're not being too permissive just because we're in that 13 and up age group. So of course, we're not done at the federal level. So it's been an active regulatory season, and before we talk about state laws, it's important to note that the education data privacy picture at the federal level is not complete. There have been a number of federal bills proposed over the past several years, from rewrites of FERPA to wholly new legislation. The two I've listed here are the ones that we've seen the most activity around of late. However, there are some others. So the two that we're seeing the most activity around and that we expect to see more activity around this fall are the Student Digital Privacy and Parental Rights Act from Representatives Luke Messer and Jared Polis. And then the Safe Kids Act, which is essentially the Senate version of the bill from Senator Daines and Senator Blumenthal. And I'm not going to go into the details of these bills. However, they're available online if you'd like to dig through them. But the key concepts are pretty consistent. They tend to call for increased transparency about how data is used, both on the part of vendors in their relationships with schools and districts, and on the part of schools, districts, and states in their relationship with parents. Data use limitations, a lot of governance controls, I would say, around what the data is used for, and restrictions against using personal information or personally identifiable information from the education record for targeted marketing, specific type of marketing, and then some fundamental shoring up of maintaining that school system control over the data. So that's happening at the federal level, and we expect more activity around that to come. But let's turn our attention to the state level. And this may not be something that has completely hit your radar, as I imagine many of you are focused on what's happening in your own state. But it may be interesting to note that the privacy conversation and the legislative activity has really traveled across the country, and we've seen an exponential growth in student data privacy regulation. Many states had privacy laws and have had them on the books for some time, not particularly student data privacy laws, but some states, such as California, have always recognized an individual's right to privacy, and several states also have laws regarding secure record disposal, disposal of records that contain personal information. But as you can see from some of these stats here, states have been extremely active creating student data privacy legislation. The number of laws directly regulating student privacy has dramatically increased in the past 3 years. Since 2014, we've seen 49 states introduce over 400 bills, with at least 100 bills introduced each year. And these laws either regulate the educational agencies and institutions, or they regulate the vendors. And there's a trend happening there to move towards regulating the vendors. Last year, we saw 46 states introduce 182 student data privacy bills, which was 72 more than in 2014. And of the bills that were introduced, 15 states passed 28 laws, which again was about on par with the results of the year before. There are a couple of laws to pay attention to here, not only because they introduced some new concepts, but also primarily for our purposes here today, because they're being modeled widely across the country. So about 33 states have introduced either a version of California's Student Online Personal Information Protection Act, or a similar piece of legislation that regulates industry known as the Super Act, which is Student User Privacy and Education Rights. And 12 states have passed those bills into law. And as you can see from the numbers I'm quoting to you are probably dated by the time they're escaping my lips here, because this climate is moving quickly. So SEPIPA and SUPER and other state student data privacy laws tend to be in contrast with FERPA in that many of them impose direct liability on ed tech operators, not schools and districts. So the entire purpose of states seeking to pass SUPER, SEPIPA, and other student data privacy laws is to fill in real or perceived gaps in FERPA and to directly regulate private companies. And I'll talk about SEPIPA in a minute, but I want to touch on another important California law that's been impactful, and that's the Privacy of Pupil Records provision of the California Education Code, commonly known by its bill number, Assembly Bill 1584. The law authorizes educational agencies to contract with third-party providers for educational software, for storage, or management purposes, but in order to do so, it requires that contracts between vendors and schools include certain provisions, such as stating that the pupil records are the property of and under control of the local educational agency, specifying what measures the tech provider has to take to ensure the security and confidentiality of the pupil records, explaining how the vendor and the school are going to work together to ensure compliance with FERPA. And the reason this has been an interesting climate to watch in California is that together SEPIPA and AB 1584 create a very comprehensive suite of data privacy regulations, and we're seeing other states imitate that. We're seeing other states include requirements for their contracts and include provisions that SEPIPA contains. SEPIPA applies to operators with actual knowledge that their product is being used primarily for K-12 purposes and that it was designed and marketed for K-12 purposes. It doesn't apply to general audience products, even if those products are accessible through a K-12 vendor product. You don't need to have, an operator doesn't need to have a contract with you in order to have to be subject to SEPIPA, and again, that's a trend we're seeing across the states. Instead, the need to comply is based on the design and marketing of the product, and super bills operate in much the same way. There's some key provisions that are that came out in SEPIPA, and again, important because they've been imitated across the states. SEPIPA requires that operators may not engage in targeted advertising on their product or outside of their product when the targeted is based on information including covered information, persistent unique identifiers that have been acquired because of the student's use of that operator's site. It prevents operators from using information, including persistent identifiers, created or gathered to match the profile on a K-12 student, except to further the K-12 school purpose. It specifically precludes selling a student's information, and that is something that, again, is basically precluded already at the federal level. And it precludes disclosing what they refer to as covered information except in specific limited circumstances. And it requires operators to maintain reasonable security procedures, to protect information from unauthorized disclosure, and to delete the information, the protected information, at the end of the contract or as requested by a school. The one piece to note about SEPIPA, and again, a trend across the state, is that the definition of what's considered personal information is growing. It's much broader than it started out in COPPA and even in FERPA. So SEPIPA refers to covered information as being specially protected, and that is defined as personally identifiable information in any media or format that was created or provided by the student, the parent, created or provided by an employee or agent of the school or the district, or gathered by the operator through the use of the site, service, or application. And it includes 29 identifying factors, including the ones you would normally expect, such as name, email address, home address, but also includes special education data, test records, biometric information, food purchases, religious information, photos, voice recordings, geolocation. Much of this data is already protected under federal law, but worth watching these definitions. And then the super bills really align very well with SEPIPA in a lot of ways, but the super bills are really based more off of the Student Data Privacy Pledge, which is an industry self-regulatory effort in which vendors pledge to maintain comprehensive privacy and security provisions around student data and to operate in very specific ways. And there's a great website available where you can read all the provisions of the pledge if you're not already familiar with it and see all of the vendors that have signed that pledge. So what's coming in this year? So far we've seen 34 states introduce another 112 bills addressing student data privacy, and 15 states passed 18 new student data privacy laws so far. And again, the trend here is really to govern the service providers. Many of these bills have contract requirements. Several of them include specific provisions that must be included in the contract between vendors and states or districts. We've seen California, Colorado, Connecticut, other states following suit in requiring specific contract provisions. Greater transparency around how states and districts are managing student information. Sometimes that means vendor contracts are available online to parents, and in other cases it means the schools and districts need to be more clear with parents about what data they're collecting. So really we're talking about more governance, more control around how vendors operate in relation to student data and in their partnership with schools and districts. And I think what we'd like to do now is talk a little bit about, I know I've gone through quite a bit of law, we want to talk a little bit about some resources that are available to help you dive into this a little more fully and give you some places to jump off of here. And Andy, did you want to walk through these resources?
Sure. So the first one up there, FERPA SHERPA, is put out by the same organization that initially came up with the pledge, one of the two organizations. So it's a great website for everyone working with student data, whether it's service providers, parents, school officials, policymakers, etc. So that's a great place to start. Of course, the U.S. Department of Education has a whole section about privacy. It's the Privacy Technical Assistance Center that's managed by the Department of Education, where they have a lot of resources, a lot of webinars that you can look at to get information, a lot of good background information. Excuse me. And then PTAC also has, as part of that, the Protecting Student Privacy While Using Online Educational Services model terms of service. So that's something to look at as well in conjunction with the others. COSN, of course, has their privacy toolkit for school leaders that you can find on their website that also provides a lot of additional information that's specifically created for you guys. So that's a great resource. Data Quality Campaign is a great organization that tracks the use of information in the state laws and just beyond privacy. If you're interested in the use of student data, it's also a great resource. And then they have their What is Student Data guidance that you can see on their website as well. Connect Safely Educator's Guide to Social Media, and then the Connect Safely FPF PTA Parents Guide to Student Data Privacy are also great resources. Did we have another question? Oh, I think we're good. So there's just some great resources. I also wanted to go ahead and extend my email address. If anyone has any questions, I'm happy to talk about privacy with anyone and help answer questions. You can get in touch with me directly at privacy@mheducation.com. Again, I'm happy to answer any questions you might have. And then if you do have any questions, now would be a time to ask. While we're waiting for any questions to come in, Lynette, did you have anything else you wanted to add to that?
No, I think this is a great start, and I hope we'll provide folks with some fundamentals around data privacy. There's some great resources here. I'll also say, and I was not prompted to say this, but McGraw-Hill has done a really nice job. They've got a really nice privacy center. If you're interested in learning more about their privacy practices, they're one of the vendors in the space that's doing a really nice job around transparency there and providing some extra information, some good plain language information about the data practices, which is something all vendors are encouraged to do. And I'm also happy to join Andy in answering any additional questions. If anyone would like to reach out, Andy knows how to reach me, but you can also reach me at lynette@playwell-llc.com. Highly Googleable, so don't hesitate to reach out with questions and getting into the nitty-gritty of this.
All right, it doesn't look like we have any questions. So again, feel free to reach out to us if you have any questions in the future. And thank you for taking your time and talking with us about privacy today. Bye, everyone.